Hello, America. I'm Mark Levin, and this is Life, Liberty, and Levin, and this is also a sad day in American history, one of the saddest, quite frankly. The Democrat Party and the Biden administration know no limits for the retention of power. Simply no question about it. Joe Biden said the other day that he had nothing to do with any of this when it comes to the investigation of Donald Trump. He's a liar. He's a liar about shell corporations. He's a liar about money from communist China. He's a liar about money from Ukraine, a liar about money from Romania. He's a liar about documents. He's a liar about his own history. We have a man in the Oval Office who is a pathological liar. But that said, Biden signed off on FBI review of Trump records, National Archives letters reveal. This is from August. What are they talking about? Biden White House, at the request of the Department of Justice, signed off to have the FBI and intelligence community to examine hundreds of pages of classified information former President Trump had. NARA informed the Department of Justice about the discovery, which prompted the department to ask the president to request NARA to provide the FBI with access to the boxes at issue so that the FBI and others in the intelligence community could examine them. So there you have NARA going to the Department of Justice, which is extraordinary. The Department of Justice saying, wait, you can't come to us directly, you have to go through the White House. Then they go back, circle back to the White House counsel's office, and Joe Biden. And they agree to send the matter to the Department of Justice, knowing damn well what would happen. And that's what triggered the entire thing. General warrants, the Fourth Amendment of your Constitution, the Bill of Rights. This warrant that was issued by a federal magistrate judge. The framers of your Constitution hated general warrants, or what were called writs of assistance. Why? Because they were used by the king to rummage through their homes, to rummage through their businesses in search of criminal behavior. And federal prosecutors have been chopping away and chopping away and chopping away at this over the years, now to the point where they have chopped it off a limb in the case of Donald Trump. Here's what your Fourth Amendment says. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. So what's probable cause? That is a reasonable basis to believe a crime was committed. They had no reasonable basis to believe a crime was committed, even if Donald Trump had classified information, which he did, because it's not a crime. It's not a crime for him to possess it, not under the Espionage Act or any other law. When Donald Trump left the White House, he was President of the United States. When he arrived at Mar-a-Lago, he was President of the United States. Whatever he took with him, you cannot then turn around and say he violated the Espionage Act of 1917 and try and charge him with espionage. And DOJ did not act in good faith, which is required under these circumstances too. America's founders hated general warrants, hated them. But the government has resurrected them. Remember the other day there was a report that, oops, we're sorry, we have 1 million cases where innocent citizens were monitored. Remember that? That's a general warrant. Here's a piece from the Washington Post several years ago by Henry Farrell. 4 centuries prior to the U.S. founding, English jurists and legal scholars rejected general warrants as the worst exercise of tyrannical power. As Sir Edward Coke announced in Parliament in 1628, if general warrants be used for the matter of the state, then we are gone, and we are in worse case than ever. If we agree for matters of state, we shall leave Magna Carta and other statutes and make them fruitless, and do what our ancestors would never do. Sir Matthew Hale, William Hawkins, and others went on to condemn them, as did our founding generation. Now they're in use. Here I have it. Here's the warrant. The warrant says, among other things, the search warrant, not including the affidavit, signed and approved by the court, August 5, 2022. And in part it says, attachment A, the premises to be searched, which they mentioned Mar-a-Lago, It is described as a mansion with approximately 58 bedrooms, 33 bathrooms on a 17-acre estate. The locations to be searched include the 45 office, the president's office, all storage rooms, all other rooms and areas within the premises used or available to be used by the First Lady or the President and his staff, and in which boxes or documents could be stored, including all structures or buildings on the estate. Sounds pretty broad to me. It does not include areas currently, at the time of the search, being occupied, rented, or used by third parties. This is a huge property. I know, I've been there. That seems pretty broad to me, and here's the affidavit. At least 2/3 of it is totally blacked out. See it? Remember this? And this redacted search warrant affidavit, and it says, among other things, under 18 U.S. Code 793, whoever having unauthorized possession of, access to, or control over any documents or information relating to the national defense, which information the possessor is reason to believe could be used to the injury of the United States or to the advantage of any foreign nation, willfully communicates, delivers, and on and on. Espionage Act. Any person, but not the President of the United States at the time of the removing of the documents, or even the former President of the United States. This is incredible. This is a defective search warrant on many grounds, as far as I'm concerned. What about the Fifth Amendment, due process? Has Trump received due process? What does it say, the Fifth Amendment? Your Fifth Amendment. No person shall be deprived of life, liberty, or property without due process of law. Obviously, that includes the right to a lawyer. Even the Mirandizing of a mass murder. You know, you have a right to a lawyer. You don't have to speak to us. All right, I'll take the lawyer. Because it's believed correctly, you cannot be properly defended if you're accused by a government. And yet, in the case of Donald Trump, his lawyers were brutalized. In Washington, D.C. court, judge rules Trump lawyer must testify in documents inquiry, New York Times. A federal judge has ruled, this is in March, that prosecutors overseeing the investigation of former President Trump handling of classified documents can pierce assertions of attorney-client privilege and compel one of his lawyers to answer more questions before a grand jury. In making her ruling, Judge Beryl Howell, this is on the last day she served on the court, then she retired, an Obama appointee, found that the government had met the threshold for a special provision of the law known as the crime fraud exception. That provision allows prosecutors to work around attorney-client privilege when they have reason to believe the legal advice or legal services have been used in furthering a crime. This is extraordinary. To do this against a former president, the leading candidate for the Republican nomination, who has authority to remove documents? No statute can trump the Constitution of the United States. Why does the president have this authority? Because he is the executive branch. That's why. He doesn't report to inferior employees. They report to him. They're not even in the Constitution. He's in the Constitution. And not only that, a liberal, Democrat-appointed federal judge agrees with me. Her name is Jackson. Bill Clinton had stuff in his sock drawer. And Judicial Watch sued, and they said, we want that stuff. And in part, here's what Democrat, another Obama-appointed judge, said in response in defense of Clinton. Under the statutory scheme established by the Presidential Records Act, the decision to segregate personal materials from presidential records is made by the president during the president's term and in his sole discretion. That's what she wrote in March 2012. It was never appealed. She said, since the president is completely entrusted with the management and even the disposal of presidential records during his time in office, it would be difficult for this court to conclude that Congress intended that he would have less authority to do what he pleases with what he considers to be his personal records. She said he has complete authority to make such decisions. But what about the Espionage Act? Remember, the Presidential Records Act does not have a criminal penalty. The Espionage Act. It would be 18 U.S. Code, Section 793, gathering, transmitting, or losing defense information. Well, what about that? October 2022, the American Bar Association, hardly a conservative organization, talking about the Espionage Act, this case, and presidential powers. Here's what they say. They conclude this: the scope of the documents taken by investigators from Mar-a-Lago is not publicly known, nor have any charges been filed. Of course, they have been now. The Constitution, executive orders, and case law clearly give the president broad authority to classify and declassify documents. Similarly, prevailing law also requires federal officials to follow certain procedures in declassifying documents. Federal officials, the president is the president, to establish specificity and memorialization for future handling. But the extent of a president's legal authority to unilaterally declassify materials without those formalities has yet to be challenged in court. So what we have here is a rogue prosecutor and rogue attorney general says, okay, we'll challenge it in court. We're indicting you. Is that the way, ladies and gentlemen, we're supposed to figure this stuff out, even if you believe there's some conflict or confusion? No, I don't think so. That's not the way it's supposed to work at all. Now, what about this issue of obstruction, ladies and gentlemen? Well, the Department of Justice took a position on obstruction when it came to the Espionage Act, the Presidential Records Act. They took a formal position when it came to the former Secretary of State, the Democrat nominee for president in 2016, Hillary Clinton. They said, we will not prosecute such cases. That was the position of the Department of Justice. That's their precedent. And the Hillary case is much worse than you know. Peter Van Buren, a national security attorney and formerly of the State Department, he wrote a commentary in Reuters. He said, there was no electronic connection, remember all the emails and the servers, between the government's classified systems and Clinton's unclassified server. This indicates that on 110 separate occasions, Clinton and or one of her correspondents had to have retyped or copied and pasted information from a classified format. There's no other method to transfer data. Classified markings such as top secret were removed in the process, though Comey at the time did say some marked emails classified were found on the server. He's saying there were more than some. There were a whole lot. He goes on, Hillary Clinton's earliest statements that no classified information traversed her server later changed to no marked classified information. Comey explained emails found in others' inboxes, messages not turned over by Clinton to the State Department, were work-related. Clinton claimed she turned over all work-related emails. Despite this, the questions of perjury and obstruction of justice were not addressed. In addition, Comey stated Clinton's lawyer deleted all emails they did not turn over to the Department of State and then cleaned their devices in such a way as to preclude complete forensic recovery. He added, it's also likely that there are other work-related emails they did not produce to State and that we did not find elsewhere. None of this was addressed in the context of destructive evidence. In other words, none of it was addressed by the Department of Justice in relation to obstruction of justice or conspiracy to obstruct. The director of the FBI labeled the leading contender for the presidency and her staff as extremely careless in the handling of America's secrets. In the current political climate, this is generally seen as positive news by Clinton supporters. The new standard apparently being not under indictment. Few believed rightly or wrongly that Hillary Clinton would face criminal charges over her handling of classified material, yet the questions not addressed by the FBI remain. Obstruction, false statements, which they've now applied to Donald Trump. That was the position of the Department of Justice 11 years ago. But it's not the position of the Department of Justice today.
Hey, Sean Hannity here. Hey, click here to subscribe to Fox News YouTube page and catch our hottest interviews and most compelling analysis. You will not get it anywhere else.